so that leaves file 22-534-FC, People versus Thomas Hernandez. We're here today for a hearing on a motion to quash a subpoena, and we are proceeding today partially by Zoom and partially by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Wilson for the Attorney General.
Yes, good afternoon, Your Honor. Monica Wilson, Assistant Attorney General. I am here on the matter of quashing the subpoena issued to Ms. Russo-Bennett.
All right, Mr. Amadeo.
Good afternoon, Your Honor. William Amadeo, P76194 for Mr. Durham, Mr. Hernandez. We all appear via Zoom. Consent to such, and thank you for allowing that.
All right, and Mr.
Douglas Gucher, on behalf of D'Angelo McWilliams, who is the co-defendant in the matter of People v. Thomas Hernandez and D'Angelo McWilliams.
All right. Ms. Wilson, this was your motion to quash the subpoena. I'll give you an opportunity to make your oral argument at this time.
Yes, Judge. Again, Monica Wilson on behalf of Ms. Russo-Bennett. Your Honor, in this matter, the defense counsel have issued a subpoena to the assigned Assistant Attorney General that is handling this matter, and I think that is inappropriate for a number of reasons, but most importantly, that the information that tomorrow's hearing is about has to do with the policy and procedures of the Ypsilanti Police Department, their record retention, their record creation policies, and all of the information that they seek to discover is available through Ms. Lowry. And case law is pretty clear. You can only call the prosecutor assigned to the case if you cannot get the information from anywhere else. And again, whatever the policy of Ypsilanti may be, may not be what it was, what it is, that's the subject of tomorrow's hearing, but all that information is available through Ms. Lowry. Ms. Russo-Bennett is an Assistant Attorney General. She does not know the policy and procedures of Ypsilanti, their police department. So and anything that Ms. Lowry told her would be hearsay, but more importantly, it has nothing to do with the policy. So the information that defense counsel is seeking has to come through Ms. Lowry, not Ms. Russo-Bennett. So for that reason, we believe the subpoena should be quashed. If you look at defense counsel's responses, it's mostly what ifs. What if Ms. Lowry says this? What if Ms. Lowry testifies or doesn't testify to this? And they seek to go on a fishing expedition with Ms. Russo-Bennett to essentially get her off the file as prosecutor, because then she becomes a witness, and that's not inappropriate. She was told information, she relayed it along. Defense counsel, I believe, asked her to further clarify this information with Ms. Lowry, which she did. So she was attempting to, not sure the word here, pass along the information that they requested. And so now they're trying to use that against her, which again, it's not appropriate. And Ms. Lowry is the source of the information that they seek. And that is the subject of tomorrow's hearing.
All right, Mr. Amadeo, Mr. Gucher, I don't know if you've discussed who wants to go first, but I'll defer to you.
I'll go first.
I'll defer to Doug.
Your Honor, that's not an accurate recitation of what we're having occur tomorrow and what we're arguing. Tomorrow's an evidentiary hearing. We've not filed a motion to disqualify Ms. Bennett from the case in chief. I believe there's two distinct issues here. The criminal sexual conduct case is separate at this point in time. This is an evidentiary issue on the discovery issues that have been ongoing in this case. The court has records starting at the very beginning of this file back in August 2020, where discovery requests were made for all recorded interviews. In this case, we were told at the time that they would provide all discovery. I didn't receive it. I've been on the case. I'm the only attorney that's been on this case since the beginning. We've gone through at least 7 different assistant prosecutors I've dealt with on the case, some just standing in. I've dealt with 4 different circuit court judges. There's been no continuity on this thing. And each time we start over with a new prosecutor, a new judge, we have to start back at the beginning. And we ask questions, and we started getting weird responses. I'd asked for all recorded interviews they refused or did not provide me with the co-defendant's interview, which they said was recorded by FaceTime. They had used a hidden recorder to record my client one time, and they did it in the open another time. Those were the only recorded interviews we got. And when I got the reports, I looked at them, I said, why, the complainants were interviewed the same way, why don't we have those? And the prosecutor said, well, let me check. Came back and said, the Ypsilanti Police Department has a policy, they don't record complaining witnesses on these types of cases. Didn't like the answer, but that was the answer they gave me. So that was prosecutor number one, Vela. He leaves the case at some point in time. I don't get the recording of Hernandez. And you'll see in the court files that there's a motion then filed by myself to obtain the recorded interviews, all recorded interviews, specifically Hernandez. And the reason I said specifically Hernandez is because it's the only one that I was told that I didn't have. So I'm misled at the beginning by the prosecutor handling this case. Because as we find out later in September of 2023 on the eve of trial, they did record those, they just destroyed them. There was that policy that he cited to me was incorrect. So I make a second discovery request because we don't get the Hernandez interviews. Again, there's a stipulated order that says we'll give you everything, including all recorded interviews. This is by the Jackson prosecutors, a signed order in your court file that they stipulated to.
I'm sorry to interrupt, but you're talking about a lot about a Hernandez interview. That's not an interview that's an issue here, is my.
It isn't, it is, and it isn't. At this point in time, I do have that, but I'm going to explain to the court why this is all connected to why Bennett is a witness in this case. They give me, they said that they'll stipulate to it. They don't give me the Hernandez interview, but they signed an order, a stipulated order saying they give me the Hernandez interview and all recorded interviews they had. They don't give it to us. We get a new attorney. Kelly Carter comes in on the case. Kelly Carter says, I file another motion, a second motion to compel the discovery. And specifically, I'm asking only for Hernandez. I'm never asking for the complaining witnesses because I've been told there was a policy they didn't record them. So Kelly Carter ends up getting me the Hernandez interview. So that's, I think I have all the recorded interviews. We ended up having an expert witness motion that was filed. On the day of the trial, there was an ancillary issue regarding one of the police witnesses from Eastern Michigan said that there was false information in our police report that we were given. I asked the Attorney General's office what the false information was, and the response I received was, you'll find out at trial. I said, no, that we can't do it that way. We've got to have an evidentiary hearing on it. She said, no, you'll find out at trial. That's, that's all that I know. They refused to find out what the information was that was false. They said, we'll find out at trial. Well, Judge O'Brien said, no, we're going to have this issue now. We're going to figure out what's going on. We're not doing it in front of a jury. And as Mr. Amadeo and I are cross-examining the Eastern Michigan officer as to what she said was false in Detective Kopic from Ypsilanti's police report, Kelly Carter stood up in court and said, I think I told you guys this, but I have a recorded interview of the interaction between Kopic and McLennan. It's the very first time we ever heard anything about a recorded interview of a witness in this case that hadn't been turned over to us, that was hidden from our knowledge. We had no idea about it. Kopic had showed up at that court hearing, evidently provided Kelly Carter, to my knowledge that day. I don't know if she knew about it prior to that or not, but on that day, they turned over that recorded interview.
Kopic, I'm sorry, what recorded interview?
The interview that Detective Kopic did with Officer McLennan.
Not helpful for me.
Officer McLennan was an Eastern Michigan University police officer. There was a dispute over whether or not there was a recording made of the two defendants in this case when they were victims in the case initially. The Attorney General.
So,
yes.
The interview you're telling me was discussed at this hearing was an interview of who? Officer
McLennan.
So one police officer interviewing a second police officer.
Correct. They were recording to find out. Originally, these cases began with Hernandez and McWilliams being victims of online harassment by one of the complaining victims, in this case's ex-boyfriend. And he was prosecuted. Eastern Michigan started that case And according to the reports of Ypsilanti Police Department, there were recorded interviews of both McWilliams and Hernandez. McLennan, who was the investigating officer at the time, said that that was untrue. There wasn't one. They were in a recorded interview room, but because they were victims of harassment, she didn't record those interviews. But we were unaware that her statements being made and interviewed by Copic to find out about that were actually recorded, even though there had been multiple requests, discovery requests for all recorded interviews to be turned over to us. They hadn't. So in the end of 2022, I believe, is that hearing. It could have been in the beginning of January 23. They turned over another recorded interview to us that Ypsilanti had that they had failed to disclose to us. They were withholding it. So we've had this ongoing issue with discovery and with multiple prosecutors. We had this matter set for trial. It was supposed to begin jury selection on September the 11th of 2023. On September 5th, I was out of town on a brief vacation for a couple of days. I get a phone call from Mr. Amadeo. He said, "Have you seen your emails?" I said, "No." He said, "Take a look at them. They're telling us that they..."
Okay, sir, I respect your desire to tell me the story, but I need you to be more concise.
Okay.
So.
Bennett's had the interview. Bennett's on that day, for some reason, got a phone call or talked to Detective Lowry, who disclosed that she lied. That there actually was recordings at one point in time, but they were destroyed. And we had transcripts from a companion case of People v. Bujaki, which have been attached to our motions, which show that Lowry, when she testified, knew that she had testified to in another case involving one of the fraternity brothers. That is a policy of Ypsilanti. They do not record victims' interviews. They were not recorded. She doesn't have to record them. The defense counsel said, "Detective Lowry, don't you think that would be beneficial for a defense counsel to have?" She said, "Absolutely, but I don't have to do it. I don't do it." Okay, we get an email from APA or AAG Russo Bennett, who says, "Yeah, they did record them. They just didn't retain them," is her words. They were destroyed. And she said there was a policy that Copic taught this officer who testified in another case that there was no such policy, that she didn't record the interviews, that they actually did record them. They just didn't retain any of them. So Lowry now is being called in as a witness in this case. There's only two people on that phone call. If you look at People v. Tesson, the prosecutor in that case, Mr. Rose, who was disqualified from the case, is the actual at a trial, not at the evidentiary hearing that they had, which I don't know if Rose actually testified at the evidentiary hearing or not. But the court found that they was the only two people in these interviews. The only person that could testify to what actually happened during the course of that interview was Rose and the individual. And if they disqualified Rose, even though 5 other people observed her. In this case, this is an evidentiary hearing. This isn't a trial. This is an evidentiary hearing on what happened in on that phone call. Since that incident has occurred, they've kind of tried to qualify what actually was said. I got an email that said that there was a policy that they recorded the interviews and they weren't retained. Now they're telling me they don't know if that's actually what happened or not. So I anticipate what's going to happen is Lowry is going to say, try to rectify her previous testimony, which would be false, which would be perjury. And now that she's going to be confronted with obstruction of justice, false police reports, misconduct in office, federal civil rights violations on every case that they've investigated that they've withheld this from, that she's going to deny this conduct. The only witness that could testify to what she was told is Russo Bennett's. And it's limited to the issues that are present in this evidentiary hearing, not the trial itself. There's been no motion to disqualify her. In the case that they cited in a Petrie, there was multiple, there's other considerations. It's not just, is there another person who can testify? There's no one that can testify to what she wrote in the emails to us. There's no one that can testify.
Let me just stop you there. Why is what Attorney Russo Bennett wrote to you in the email, isn't the issue whether or not there was a policy?
No.
What is the issue then?
Whether or not they were destroyed and why they destroyed them.
Well, there's no dispute that they were destroyed, is there?
Yes, according to Ms. Bennett's in the hallway when we discussed it with her, she said that's not exactly what she said. She said she did it on one case. I don't know if she did it on the other cases. So now it's become, what do you mean you don't know? You sent us an email that said that they had a policy. So, but she also,
let me
Yeah.
There's now a dispute as to what was said in a conversation between you and Ms. Russo Bennett?
No, between between what she sent us and what, evidently what was said to Ms. Russo Bennett and Lowry, and what's been conveyed to us. The only person we've ever spoke to is Russo Bennett on that. And she's now trying to qualify what was actually written to us, saying it doesn't mean what it says. She's only sent me one email on this.
Okay, I'm not.
There's a second email.
I cannot understand from you what the essential piece of information is that Ms. Russo Bennett has that needs to come up from her.
What Lowry told her.
Sir, can you let me finish my question?
Sorry,
this is, as you know, we record these. We have to create transcripts. Why is what Lowry told her relevant to the decision that I have to make about whether or not there was a Brady violation?
Because that's the only information we have. I don't know.
That doesn't answer my question.
What do you mean? Well, Your Honor, the Brady violation is based upon what was disclosed to us by Russo Bennett.
How is it based on what was disclosed to you by Ms. Russo Bennett? So I'll just tell you, the way I see this is that the Ypsilanti Police Department either had a policy that they recorded and then destroyed interviews of victims, or they didn't have a policy.
There was no such policy.
And what evidence of that is there?
Ms. Russo Bennett sent an email to Bill Amadeo. She didn't send it to me. It's after the one she sent on September 5th. And she says that she was told that it expands on what she said to me in the email. And it says something to the effect that that's the way she was trained. There was no actual written policy on that. So we know there's no policy. But that again comes from the conversation that evidently only Ms. Russo Bennett and Lowry had. It's a November 1st email. Lowry took over. This is from Ms. Bennett, Russo Bennett, to Bill Amadeo on November 1st of this year. Lowry took over the Detective Bureau on October 22nd. She advised her detectives that they were to retain all digital evidence going forward. There is no written policy, and she indicates that they don't take part in writing policy. The first part of this says there's no written policy. Lowry says this is how Annette Kopic trained her to do in the Detective Bureau when Kopic was her supervisor regarding policy.
All right, so all right, is there anything else you want to say?
Well, Your Honor, the only disclosures that we have come from Russo Bennett. I have one from September 5th that she sent me. That was the 2023 one. There was subsequent emails, but
What are the disclosures?
hi, Bill and Doug. Bill, I believe you've asked Detective Lowry about whether she had any recorded interviews of the victims on this case. In talking to her about this, Detective Lowry clarified to me that they don't have any recordings of the victims. But per Kopic's policy at the time, when she was heading up the Detective Bureau, the victims are recorded for note-taking purposes to write the reports. Afterwards, the recordings themselves are not retained. Detective Lowry states that since she has taken over the Bureau, she has changed the policy and now retains victims' interviews. But she does not have recordings of victims and interviews here in our case. I want to make sure I pass that information along. What's going to happen and why Russo Bennett is important in this case is we believe that Lowry, when she testifies, will not testify to that. And if that's the case, the only person to destroying the interviews. Because we have sworn testimony in the Bujaki case in which she denied ever doing that. She said there was no policy to record interviews, so they never did it. The two can't be rectified. Either she's going to come in and admit that she committed perjury in the Bujaki case, or she's going to say she's been destroying evidence in cases all along. And the only way to impeach her or to make sure that the testimony is consistent is to have AAG Russo Bennett as a witness in this case. If we're not disqualifying her, moving to disqualify her from the trial in chief. This is an evidentiary issue. This is not a trial issue.
All right, Mr. Amadeo, do you have anything you'd like to add?
Yes, Sharon, I'll be brief. When I got the email from Danielle Russo Bennett on September 5th, I was somewhat shocked because we've been told all along that these are
okay, Mr. Amadeo, I appreciate that you were shocked, but I am going to make my decision here today based on the facts and the law. So I would like to stay tightly focused on those two things.
So with that being said, Judge, and I'm going to be concise, the only two people we could question about Ypsilanti police policy is Annette Kopic and Jessica Lowry. Annette Kopic has evaded service, even with the help of the Attorney General. With that being said, the only information we got that the Ypsilanti Police Department systematically destroyed evidence comes from the email of Danielle Russo Bennett. If Jessica Lowry were to take the stand and deny what Russo Bennett's got in that email, we could be stuck with her answer and she can in essence perjure herself. We got to go through other things. We have other evidence to impeach her with. The information between Russo Bennett and Lowry only comes from those two. We need Russo Bennett sequestered. And in essence, Russo Bennett could almost be a rebuttal witness if Lowry is to lie on the stand. This case has been going on 4 years, Judge. It's critical that we have the opportunity to question Russo Bennett with the email because Lowry would not talk to us and Kopic cannot be found. For those reasons, Judge, in the most simplistic manner, Russo Bennett should be a witness. That's all I have to say on that issue, Judge.
Ms. Wilson, do you care for rebuttal?
Just very, very briefly, Your Honor. And I think your questions to Brother Counsel picked up on this. The question is, what was the policy of the Ypsilanti Police Department, whether or not it was followed about these videos? Miss Russo Bennett does not have personal knowledge of those policies or what happened. The first two prosecutors they cited, one was Mr. Velez from Washtenaw County, as well as Jackson County. So again, those are matters that the Ypsilanti Police Department can testify to, not Miss Russo Bennett. So I think, Your Honor, we would just respectfully request that you quash this subpoena.
So the issue in this hearing is I suppose what the policy of the Ypsilanti Police Department was with respect to recording and destroying recordings and or destroying recordings of interviews with victims at the time that these events occurred, and also what Detective Lowry's understanding of that was, whether it be a policy or training or whatever the correct word is for it. Detective Lowry is going to testify about that tomorrow. There is potential for defense counsel to impeach or want to impeach Detective Lowry, depending upon what she testifies to. Obviously, none of us can know what that will be at the moment. It does appear from what the defense has presented that Attorney Russo Bennett may have information regarding an admission of what Detective Lowry said with respect to that training or policy that could, depending upon what Detective Lowry says during the hearing, be valuable impeachment evidence. And it also appears that Attorney Russo Bennett is the only person that would have information about that admission. So the way the court will intend to proceed tomorrow is to have the parties call Detective Lowry as the first witness, and during that testimony, Attorney Russo Bennett will be sequestered so that the court can understand whether that testimony will be necessary during the continuation of the hearing. If it is, then I think that Attorney Russo Bennett would need to testify with respect to what Detective Lowry told her, because it is, as I said, potential impeachment testimony. If she testifies consistent with what she told Attorney Russo Bennett, then it wouldn't appear to me that her testimony would be necessary. But either way, I think we can resolve that as efficiently as possible by calling Detective Lowry first, having Attorney Russo Bennett sequestered during that testimony, and then proceeding from there in an appropriate fashion, depending upon the testimony of Detective Lowry. So is going to be the court's order, and that's how I'm going to be handling it tomorrow.
Your Honor, one procedural question for tomorrow.
Go ahead.
There's 3 cases tomorrow. Hernandez and McWilliams are joined together. Durbin is a separate case. Ms. Palpapu is the Attorney General on that case. Ms. Russo Bennett is not involved in that case. Are you going to do a combined one hearing for all 3, or do you want to do Durbin first? If the issue is resolved when Lowry testifies in Durbin, then there is no issue in the second case. I should have said that earlier. But if we're going to do them all together, Your Honor's ruling makes perfect sense.
Suppose I assume that we would be doing them all together. Is there any reason that we would not do them all together?
Judge, may I speak?
I guess at this point you're represented by Ms. Wilson, and if Ms. Wilson is comfortable with that, then that's fine with me.
Yes, Judge, I think I'm only on this after this issue, so I think Ms. Russo Bennett can fill the court in.
And Danielle Russo Bennett on behalf of the people. Just as to this was always a combined hearing. This was always a combined hearing as far as Mr. Durbin. I'm not on the Durbin case, but as far as Mr. Durbin, because that's Mr. Amadeo's case. And so this was always supposed to be a combined evidentiary hearing. And in fact, when this was set in Washtenaw County a year ago, this was supposed to be a combined hearing. So I don't know why we would split it up at this point. But I also do have a pretty procedural question of my own. And that is, Alex Peterson is my second chair. This is my case. Who is conducting Mr. Thomas Hernandez and Mr. D'Angelo McWilliams's cross-examination of the witness tomorrow? I was prepared to do that since this is my case, and I'm sure it's not going to come as a shock that to Mr. Amadeo and Mr. Gucher that I was willing and prepared to do this hearing tomorrow now that they are sequestering me out. So my hope is that Ms. Wilson will be speaking to her superiors, Mr. Pallas, about an appeal of this, because this certainly causes quite an issue with the prosecution of our case tomorrow, because I was prepared to go forward tomorrow, not Ms. Peterson. She was not prepared to question the witness. I was questioning the witness tomorrow. So this is really truly unfair to the people.
And Your Honor, that was going to be my
But-
next question as to whether or not this court would be willing to entertain a brief adjournment of tomorrow's hearing. That the subpoena to Ms. Russo Bennett, it was served on her less than 2 weeks ago. We promptly filed a motion to quash. She was the person who was prepared all along to conduct this hearing, not AAG Peterson. So I would like to talk to Mr. Pallas about the potential for appealing this decision. But in the alternative, Ms. Peterson needs time to prepare if we're learning today that she's going to be conducting the examination of Detective Lowry.
And I say this, I hate even asking for it, Judge, because I hate doing this to the victims. It's been such a long delay, but it's truly not a position that I want to put Ms. Peterson in. And if the supervisors decide this is an appeal we need to take, because I think this sets a horrible precedent for prosecutors everywhere around the state, then I want to take this option. I don't want to ask for the adjournment, but I think Ms. Wilson is absolutely correct in that we either need time to decide on an appeal, or Ms. Peterson has got to get prepared to be able to question the witness, because she's not prepared to do that tomorrow. That was on me for tomorrow.
And Your Honor, if I may just briefly respond to that.
Go ahead.
Thank you, Judge. As far as Miss Wilson and Miss Russo Bennett's claiming that they got the subpoena 2 weeks ago, I've been begging for this conversation for months. So this is not a shock to the people. That's number one. I do take issue who the real victims are in this case. I'll leave my opinion on myself right now. With that being stated, Judge, we have asked the people constantly for a meeting with the court before it came to this. There's no other way than to say that Miss Russo Bennett could be a potential rebuttal witness and for impeachment purposes. No matter how unfair the people think it is, this is unfair. This case is going on 4 years with discovery that's been destroyed. So I think the ruling's correct. We are prepared to go tomorrow. Thank you.
Judge, a month ago, Mr. Amadeo.
Hey, Ms. Russo Bennett, please stop. Mr. Gooch.
Oh, I had an email. I discussed this with Ms. Bennett in the hallway before the last judge recused herself. But that aside, we have an actual email from September the 1st. Mr. Amadeo sent to Ms. Russo Bennett saying, "Do you want to discuss you being a witness in this case?" And her response was, "Contact the court next week and we can do a conference call." Palpaku said, "I'm not available next week," and they did nothing. We didn't have to subpoena them. That came from a conversation Mr. Amadeo and I had a couple weeks ago, and I said, I don't want to get there the morning of, and all of a sudden Ms. Bennett said, "I had no idea this was going to be an issue." Bill said, "I think I'll just send over a subpoena and we'll prime the pump for this." That's how this came to a head when it did. I have the email with me, if the court would like to see it, from September, where we actually put it in writing. Ms. Bennett, we'd like to discuss you being a witness in this case. As for their request for an adjournment, at this stage, I'll leave it to the court's discretion. This case has been adjourned a number of times. We've whittled down the witness list to try to make it the most efficient as possible. I think we had planned on calling Lowry and Bennett as the two witnesses tomorrow and do the rest through court records.
And Judge, while I'm prepared to go tomorrow, if you feel an adjournment's best, I have no issue with that. I just want the court to know we've been ready for a while. We are prepared for this hearing, but if the court feels an adjournment's appropriate, I won't battle that at all or challenge you, Your Honor.
All right, I believe there is good cause for an adjournment. First, because this issue was not resolved until today. I appreciate the fact that people may have discussed it or tried to discuss it previously, but it did not come to a head until this afternoon. The second reason I believe that there's good cause for an adjournment is because I do believe that people should have an opportunity to consider an appeal of the decision if that's what they want to do. Once we have the hearing tomorrow, we can't go back. And so I think for that reason that there is good cause in the form of giving the opportunity to people to request an appeal. So I'm going to grant that adjournment. Do you want to try to schedule the new date now, or would that be better done in an email chain with my assistant?
I'm missing two of my colleagues, so it probably is best, Judge, with an email chain, just so everyone can check their calendars for me.
I agree that the email chain would probably be more appropriate, so I could look at my trial docket and make sure it works for the court and the people.
Okay, I will leave it to the attorneys then to get in contact with Francis and reschedule a date.
Thank you, Judge.
Thank you, Judge.
Thank you,
Ms.
Judge.
Bennett, Ms. Bennett, September 12th was the email. I misspoke and said the 1st. If you're looking for the email.
Okay, thank you.
All right, is there anything else that we need to address today?
No, Judge,
No,
thank you.
All right, thank you. Then you can all go ahead and log out those of you who are Zoom.
Thank you, Judge.
Thank you.